Welcome to another webinar here at the New York State Comptroller's Office. My name is William Naylor with the Local Official Training Unit here in our Division of Local Government and School Accountability. And today we're going to be joined by Mark Stevens from our Division of Legal Services to talk about ethics, which no better time to talk about ethics than at election time with new appointees or elected officials, newer ones. I know talked to many newer officials over the last year. And, ethics is just something good to talk about. So with that, I'm going to turn it over to Mark.
Thank you, Will. I appreciate that. And thank you, everybody, for joining us to have an opportunity to speak on ethics. This morning, I'm going to be speaking on aspects of Article 18 of the General Municipal Law, as well as certain decisional law relating to conflicts of interest and ethics. Before I begin, though, I do want to quickly point out that on the State Comptroller's website, we have a number of resources available relating to Article 18, which you may wish to visit at some point should you have any questions on this topic. So as the slide shows, the first thing I want to talk about is the structure and scope of Article 18. Conflicts of interest refers to a concept that has very broad application and comes into play virtually any time an individual confronts some form of divided loyalty, such as dual office holding, professional ethics, and self-dealing. The focus of this presentation is on portions of Article 18 of the General Municipal Law, which is the state statute governing conflicts of interest on the part of municipal officers and employees. Note, however, that the statewide rules that I am discussing this morning do not address every type of conflict of interest. For example, Article 18 does not address the issue of whether or under what circumstances a person may simultaneously hold more than one public position, commonly referred to as incompatibility. In general, Article 18 approaches conflicts of interest in two ways. It establishes statewide rules dealing with a number of issues, which we'll discuss. It also provides broad authority, and in many cases a mandate, for the statewide rules to be supplemented through the adoption of a local code of ethics. Therefore, my goal is to provide a general framework of how Article 18 applies to you as a municipal official. Before discussing the application of Article 18, I thought I would provide some brief background. Article 18 was enacted in 1964. Prior to the enactment, conflicts of interest on the part of local government officials were governed by the common law, at least a dozen state statutes, several dozen city charter provisions, which to one degree or another codified the common law, and by a large number of administrative and judicial decisions interpreting both the common law and these various statutes and charter provisions. The legislation enacting Article 18 of the General Municipal Law was an effort to harmonize, clarify, and rationalize the law relating to conflicts of interest on the part of municipal officers and employees, but only as a means of achieving a trinity of larger purposes, those being to protect the public from municipal contracts influenced by various officers, to protect innocent public officers from unwarranted assaults on their integrity, and to encourage each community to adopt an appropriate code of ethics to supplement this chapter. Consistent with these goals, the legislation was intended to be the general law in relation to conflicts of interest in municipal transactions, not to be superseded by local law or any municipality subject to its provisions. I would like now to turn and discuss the application of Article 18 now that you have a brief history of it. Article 18 applies to municipalities, which is defined broadly to include most of the state's local government entities. For example, the definition of municipality in Section 800, subsection 4, includes counties, cities, except New York City, towns, villages, school districts, public libraries, BOCES, town and county improvement districts, county vocational education and extension boards, district corporations, which is typically your fire districts, and urban renewal agencies. Note that Article 18, however, does not apply to New York City or to most local public authorities. However, it does apply to industrial development agencies, or IDAs. Article 18 also applies to municipal officers and employees. The term municipal officer or employee is defined in General Municipal Law, Section 800, subsection 5, as a paid or unpaid officer or employee of a municipality, including members of an administrative board, commission, or other agency of the municipality. In the case of a county, the definition includes any officer or employee paid from county funds. A fire chief or assistant fire chief is also a municipal officer or employee for purposes of Article 18, but the definition does not include a person solely by reason of being a volunteer firefighter or a civil defense volunteer. Now that you know who is covered under Article 18 of the General Law, what does Article 18 deal with? Article 18 generally deals with the question of whether and under what circumstances a municipal officer or employee can do business with the municipality for which he or she serves. So how is this done? As the slide here points out, Article 18 prohibits a municipal officer or employee from having interests in contracts under certain circumstances. So how can you determine whether a municipal officer or employee has an interest in a contract that may be prohibited under Article 18? You must examine 4 issues, each of which is listed on the slide you're looking at. So this morning, we're going to kind of go through each one of these as well to explain how you go about doing this analysis. The first issue is whether there is a contract with the municipality. The second issue is, does the municipal officer or employee have an interest in the contract? The third issue is, does the municipal officer or employee have any powers or duties that could give rise to a prohibited interest in the contract? And finally, are there any exceptions that apply? If you conclude there is a contract with the municipality, that the municipal officer or employee has an interest in the contract, and the municipal officer or employee has one or more powers or duties that could give rise to a prohibited interest, the municipal officer or employee has a prohibited interest in the contract unless an exception applies. However, if a municipal officer or employee has an interest in a contract but does not have any of the powers and duties that could cause the interest to be prohibited, or if any of the statutory exceptions apply, then the interest is not prohibited, but in most cases must be disclosed. At this point, I'm going to discuss each of the 4 issues in more detail so you can have a better understanding of Article 18. Let's start with the first issue. Is there a contract with the municipality? To answer this question, you need to know how the term contract is defined for purposes of Article 18. The definition of a contract is set forth in Section 800, subsection 2 of the General Municipal Law to include any claim, account, or demand against or agreement with a municipality, express or implied. Thus, almost any business relationship with a municipality will result in a contract. Examples of contracts include purchase contracts, sale agreements, leases, construction agreements, service contracts, and even a voucher can be a contract because it is a claim, account, or demand against a municipality. Under Article 18, the definition of a contract also includes the designation of a depository of public funds, as well as the designation of an official newspaper. Note that a contract can also be oral. Usually contracts are written documents, but they don't have to be. They don't have to be in writing. Also, note that in some cases, the existence of a contract may not be obvious. For example, there is case law that has concluded that a contract between a private party and one municipality may also be deemed a contract between a private party and a second municipality if the municipalities have an overlap or identity of interest. So just a word of caution, there have been limited circumstances where a court has concluded that you may be dealing with a separate municipality. You might think there's not a contract, but in essence, there can be. We always recommend that you consult with your legal counsel if you think that's even a remote possibility. Now that we have discussed what a contract is for purposes of Article 18, I want to mention what we believe are not. The State Comptroller's Office has generally expressed a view that certain land use actions, such as the issuance of granting of building permits, licenses, zoning changes, variances, site plan, or subdivision approvals, and the like, do not constitute as contracts for purposes of Article 18. However, Section 809 of the General Municipal Law, which we will discuss later in the presentation, may require disclosure in some instances. We have also concluded that intermunicipal agreements, which are contracts between or among municipalities, are not contracts for purposes of Article 18. The idea behind that is we believe the legislature intended local governments to work together and therefore want to encourage those kind of relationships. We also have generally expressed a view that a gift to a municipality generally does not fall within the statutory definition of a contract because a gift is a voluntary transfer of property from one party to another without consideration. Now that you know how a contract is defined for purposes of Article 18, the second question you need to ask is whether the municipal officer or employee has an interest in the contract. Article 18 defines the term interest as a direct or indirect pecuniary or material benefit accruing to a municipal officer or employee as a result of a contract with the municipality for which such officer or employee serves. Whether a municipal officer or employee receives a benefit as a result of a municipal contract is a factual determination. For example, in general, a municipal officer or employee who receives payment under a contract with his or her municipality would have an interest in the contract because the payment is a direct financial benefit resulting from the contract. Moreover, a municipal officer or employee does not have to be a signatory to have an interest in the contract. As you can see here on your slide, you can also have a deemed interest. In essence, the statute provides that a municipal officer or employee is deemed to have an interest in the contract of his or her spouse, minor children, or dependents, except a contract of employment. However, a municipal officer or employee is not deemed to have an interest in the contracts of any person other than his or her spouse, minor children, and dependents. For example, a municipal officer or employee is not deemed to have an interest in the contract of his or her parents, siblings, or other relatives. Nonetheless, a municipal officer or employee would still have an interest in such a contract if, as a factual matter, he or she were to receive a direct or indirect pecuniary or material benefit as a result of the contract. Article 18 also deems a municipal officer or employee to have an interest in the contracts of certain business entities with which he or she is affiliated. In this regard, a municipal officer or employee is deemed to have an interest in a contract of a firm, partnership, or association of which a municipal officer or employee is a member or employee, or a corporation of which a municipal officer or employee is an officer, director, or employee, or directly or indirectly owns or controls any stock. Also, as I mentioned when I described what a contract is, note that an officer or employee of one municipality may also have an interest in a contract of another municipality if the municipalities have, again, an overlap or identity of interest. So just a word of caution, in some cases, the courts have found that you could have a contract even though it's a different municipality, or possibly an interest even though it's a different municipality. It is very fact specific, but it is something I wanted to at least mention. However, a generalized interest in the financial well-being of a company does not give rise to an interest. Now that we have discussed whether a municipal officer or employee has an interest in a contract, the third question is whether that individual has one or more powers or duties that could give rise to a prohibited interest. Unless an exception applies, Article 18 provides that an interest in a contract is prohibited if a municipal officer or employee, individually or as a member of a board, has the power or duty to negotiate, prepare, authorize or approve the contract, authorize or approve payment under the contract, audit bills or claims under the contract, or appoint an officer or employee having those powers or duties. Why are we concerned with whether the municipal officer or employee has any of these powers or duties? Well, the basic purpose of the statute is to prevent an individual from having the ability to influence the municipal procurement and payment processes for both sides of a transaction. Therefore, in general, the powers and duties that can give rise to a prohibited interest in a contract do not include purely ministerial functions, such as executing a properly authorized contract or issuing a check to pay a properly audited and lawful claim. Note that in most instances, a member of the governing board of a municipality will have at least one of the powers and duties that can give rise to a prohibited interest in a contract. To confirm the existence of these powers and duties, or to determine whether any other municipal officer or employee has them, the state statute or local enactment which establishes the position should be reviewed. Other sources of relevant information may include written job descriptions and employment contracts, as well as an examination of the actual functions of the position. We will touch on this a little later, but it is important to understand that if a municipal officer or employee has one or more of these powers or duties that can give rise to a prohibited interest in a contract, it is the existence of these powers and duties, not whether they are exercised, that causes an interest in a contract to be prohibited. Thus, recusal or abstention does not cure a prohibited interest in a contract. Although we do not have time to discuss each of the statutory exceptions set forth in Article 18 this morning, in general, the exceptions apply when a municipal officer or employee does not have a material financial stake in the transaction, or an opportunity to exert improper influence, or when the transaction is otherwise in the public interest. With that said, I'm going to briefly discuss a number of the exceptions set forth in Article 18. Article 18 provides an exception for the payment of lawful compensation and necessary expenses to an officer or employee in one or more positions of public employment, provided the holding of that employment is not prohibited by law. Therefore, for example, it is okay for a member of the governing board to submit a voucher for reimbursement of actual and necessary expenses. However, you may want to think carefully about participating in any board discussions or vote on your own voucher. Although I will not be addressing this topic today, the exception set forth in Section 801 of the Gentleman's Law also applies when an individual serves a municipality in more than one position, so long as those positions are compatible. Again, this is often referred to as compatibility of office, and by informal agreement, this area is handled primarily by the New York State Attorney General's office. The next exception is what we often refer to as the duties and remunerations exception. This exception provides that when a municipal officer or employee's interest in a contract is prohibited solely by reason of his or her private employment, the exception will apply if the municipal officer or employee's private remunerations, commonly known as their compensation, is not directly affected as a result of the contract, and the duties with his or her private employment do not directly involve the procurement, preparation, or performance of the contract. For example, suppose a town entered into a contract with a repair shop to repair town vehicles. A member of the town board is employed at the repair shop but works in the supply department of the repair shop. If the member of the town board does not receive compensation from the repair sales, and his or her job duties at the repair shop do not include the procurement, preparation, or performance of any part of the town's contract with the repair shop, the exception would apply. There also is an exception that applies when the contract was entered into prior to the time the municipal officer employee was elected or appointed to his or her municipal position. However, you need to be careful because the exception does not apply to the renewal of the contract. This comes up quite frequently when you have new board members who had contracts previously with the municipality. They then become on the board. The contracts that were entered in prior to the time the individual became a board member would not be prohibited. However, where individuals get themselves in trouble is the renewal of the contract comes up, you're now on the board, and the contract gets renewed, then as we pointed out, this exception would no longer apply. So again, be cautious because the exception does not apply to the renewal of the contract. Another exception also applies for contracts with a corporation if the municipal officer employee directly or indirectly owns or controls less than 5% of the outstanding stock. As we will discuss later, note that disclosure is also not required when this exception applies. The exception, however, does not apply to interests in such contracts arising from circumstances other than ownership or control of corporate stock, such as an interest arising from individual status as a corporate officer, director, or employee. In other words, while this exception does allow you to not have to be concerned if the only reason you have an interest in the contract is because of the stock holdings, however, if you have multiple relationships with the corporation, such as you're an officer and a stockholder, this exception only applies to not having an interest by virtue of your stock holdings. You would have to have a separate exception for the fact that you are an officer of the corporation. There's also a frequently encountered statutory exception that applies to contracts with a membership corporation or other voluntary nonprofit corporation or association, including but not limited to a rural electric cooperative. For example, the Court of Appeals has held that the exception applies to a collective bargaining agreement between a municipality and a voluntary nonprofit association representing the employees of the municipality. Again, this exception comes up with quite a bit of frequency. In essence, it's an exception where the contract is with a not-for-profit organization. However, we recommend under these circumstances that the individual who has that relationship should disclose the relationship, which is a requirement. We'll talk about disclosure in a minute, as well as we recommend, although not required, we recommend that the individual abstain and recuse themselves from any involvement relating to that contract as a municipal officer and employee. Another statutory exception applies if the total consideration payable under all contracts in which a municipal officer or employee has an interest during a fiscal year, which does not exceed $750. For example, the exception might apply when a municipality makes small purchases from a local hardware store owned by a municipal officer or employee. Similar to stock holdings of less than 5%, as we will discuss later, disclosure is also not required when this exception applies. I wanted to take a second here to point out, however, that while there is an exception, a word of caution, the dollar amount is fairly low, $750. You had to add up all of the contracts. So in the example with the hardware store, it doesn't take long to get above $750. So we do occasionally on audit see local officials getting themselves tripped up because they exceed that dollar amount. Also, we'll talk a little bit about your code of ethics later. It's certainly possible that within your code of ethics, there's restrictions for any purchases relating to this. So while there is an exception, just a word of caution, it's easy to go over that dollar amount. As you can see from the slide, there is also a statutory exception, sometimes referred to as the quote unquote rural municipalities exception, which applies only to purchase and public work contracts of municipalities other than counties that are located wholly or partly within a county with a population of 200,000 or less. Although I do not have time to discuss today, there are a number of prerequisites in order for the exception to apply. Therefore, you should consult with your legal counsel if you wish to use this exception. Again, there's a series of factors that have to be met in order to satisfy this exception. It has to be less than $5,000. There's another one, you can't be a paid official. You have to make sure you follow your procurement policies, and you have to make sure you don't vote on the contract. But in any event, there's a number of factors you have to meet in order for this exception to apply. So again, please use caution if you intend to use this as an exception for Article 18 purposes. There also are two statutory exceptions relating to the purchase and acquisition of real property by a municipality. Both involve judicial proceedings. One of these statutory exceptions applies to the acquisition of real property through condemnation proceedings. The other applies to the purchase by a municipality of real property or an interest therein, but only if the purchase and the consideration provided by the municipality are approved by order of the Supreme Court upon petition of the municipality's governing board. Note that there also is an exception for certain private sale of bonds or notes, as well as an exception for the designation of a newspaper for publication of official notices. Once again, you should consult with your legal counsel before relying on any of these exceptions. Finally, note that there is a statutory exception that applies specifically to the designation of a bank or trust company as a depository, paying agent, registration agent, or for the investment of funds. As I will discuss a little later, this exception, however, does not always apply when the chief fiscal officer, treasurer, or his or her staff has an interest in a bank or trust company. If you remember nothing else from my discussion on conflicts of interest, I would ask you to remember this slide. Article 18 does not provide an exception for competitive bidding or requests for proposals or when there is an emergency. In other words, oftentimes I will get questions about, well, if the local government goes ahead and competitively bids for the contract and awards the contract pursuant to a competitive bid processing or a request for proposals, or there was an emergency, is that an exception for having a prohibited interest? And the answer is no. Article 18 does not include an exception for those circumstances. Therefore, even if you competitively bid, use the request for proposals, or there was an emergency, it will not cure a prohibited interest in a contract. Moreover, Article 18 does not provide an exception when there is disclosure, abstention, or recusal. Therefore, the fact that an individual discloses the interest and/or abstains and recuses themselves from involvement with the contract does not cure a prohibited interest. We get this quite frequently when we are doing audits. There's a misconception that as long as the individual discloses their prohibited interest and recuses themselves from involvement in the contract, that's enough to cure a prohibited interest. And Article 18, once again, does not include an exception for those circumstances. So once again, if you remember nothing else, please remember that there is no exceptions for competitive bidding, disclosure, abstention or recusal, or the use of emergencies. As I mentioned a few minutes ago, Article 18 contains an additional prohibition applicable only to municipal chief fiscal officers, treasurers, and their deputies and employees. The term chief fiscal officer is defined to include a controller, commissioner of finance, director of finance, or other officer possessing similar powers and duties. The term treasurer includes the treasurer of a county. Unless a statutory exception applies, no chief fiscal officer, treasurer, or his or her deputy or employee may have an interest in a bank or trust company designated as a depository, paying agent, registration agent, or for investment of funds of the municipality of which he or she is an officer or employee. As previously discussed, Article 18 does contain a statutory exception that applies specifically to the designation of a bank or trust company as a depository, paying agent, registration agent, or for the investment of funds. This exception, however, does not apply to a chief fiscal officer, treasurer, or their deputy or employees unless the municipality would otherwise be required to designate a bank or trust company located outside of the municipality. Before I turn to the discussion of disclosure, I want to quickly recap what we have discussed so far. Article 18 generally deals with the question of whether and under what circumstances a municipal officer employee can do business with the municipality for which he or she serves. To make this determination, you must examine 4 issues. Is there a contract with the municipality? Does the municipal officer employee have an interest in the contract? Does the municipal officer employee have any powers or duties that could give rise to a prohibited interest in the contract? And finally, are there any statutory exceptions that apply? If you find that there is a contract with the municipality, that a municipal officer employee has an interest in the contract, and the individual has one or more powers or duties that can give rise to a prohibited interest, and none of the statutory exceptions apply, then the interest is prohibited under Article 18 of the General Municipal Law. However, if the municipal officer employee has an interest in a contract, but the individual does not have any of the powers or duties that could cause the interest to be prohibited, and/or any of the statutory exceptions apply to the interest, then the interest is not prohibited. In most cases, however, the interest must be disclosed. So the goal here is when you're trying to do an analysis of whether or not an individual has a prohibited interest under Article 18 of the General Law, you kind of have to walk through those 4 steps that I mentioned. Is there a contract? Does the individual have an interest in that contract? Does that individual have any of those powers or duties that could give rise to prohibited interest? If you say yes, 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 then the individual would have a prohibited interest in the contract unless an exception applies. Again, I highly recommend anytime you have a question or concern that you consult with your legal counsel, as well as we are a resource available to discuss these types of questions. But this is typically how I would go about doing the analysis under Article 18, is to ask those 4 questions. Is there a contract? Is there an interest in the contract? Does the individual have any powers or duties that could give rise to a prohibited interest? And finally, are there any exceptions that apply? I would like to now turn your attention to when disclosure of an interest is required. So here we are. We've decided there is a contract, and we've decided that an individual does in fact have an interest in the contract, either because they receive a direct monetary benefit as a result of the contract, or they've been deemed to have an interest in the contract by virtue of either being their spouse or some of a relationship with a business entity. If it is concluded that this individual does in fact have an interest in the contract, then pursuant to Section 803 of the General Law, if an officer employee or the spouse of an officer employee has, will have, or later acquires an interest in any actual or proposed contract, purchase agreement, lease agreement, or other agreement with the municipality for which he or she serves, written disclosure of the nature and extent of the interest is generally required. Also, disclosure must be made as soon as the individual has knowledge of an actual prospective interest. Disclosure must be made by the municipal officer employee publicly to the individual's immediate supervisor, assuming you have one. So, of course, if you are a member of the board, you wouldn't have a supervisor, but if you are an officer or employee and you do have a supervisor, you are required to provide that written disclosure to the supervisor. It also must be made publicly to the governing body and set forth in the official record of the proceeding. So this is very important. On audit, we will often see something on the board minutes saying that disclosure was required, but that doesn't describe the actual disclosure. The statute requires that the disclosure be made in writing and made as an official record. So in a perfect world, the disclosure would probably be a written disclosure made by that individual and attached to the board minutes for that month. That way, anyone who's interested in seeing the disclosure will be aware that the disclosure was made, as well as be able to know what that disclosure was about. Again, being able to provide that information will help alleviate any potential concerns with ensuring that an individual has complied with disclosure. The other aspect I should point out is sometimes we'll get the argument, well, yes, there was no written disclosure, but everybody on the board was aware or knew that this individual had an interest, so we didn't really concern ourselves with putting in the board minutes. That certainly can be a problem, first, because it doesn't satisfy the statute, and secondly, there's an assumption that just because the board may know that this individual has that sort of relationship, it certainly doesn't mean that the public necessarily knows about that relationship. So again, these are the type of things that have come up on audit, and again, recommend if disclosure is required, please put it in writing, put it in the board minutes, and that will help ensure that this individual is in compliance with Section 803 of the General Municipal Law. Finally, a couple other things. The General Municipal Law does provide in some circumstances that disclosure is not required. For example, disclosure is not required when the municipal officer employee's interest is based on ownership of less than 5% of stock holdings or interest in contracts less than $750 for the fiscal year. So there are some circumstances, as this points out, where depending on what the exception is, not only do you not have a prohibited interest, you also are not required to disclose. The two most common, as I just pointed out, is where your stock holdings are less than 5% and where the contracts are in less than $750 for the fiscal year. Remember, however, that disclosure of an interest does not cure a prohibited interest. That's very key here. Again, just because you disclosed, if you have a prohibited interest, that's not going to cure it. Therefore, as we discussed earlier, if a municipal officer employee has an interest in a contract and also has one or more powers or duties that could give rise to a prohibited interest, and none of the exceptions found in Article 18 apply, the municipal officer employee would have a prohibited interest regardless of that individual disclosing the interest. I know I keep saying it over and over again, but I really want to emphasize that. I will occasionally get the question coming up, all right, so Article 18 has been violated. What are the consequences for having a prohibited interest? As you can see here on your slide, Article 18 provides that any contract willfully entered into by or with a municipality in which there is a prohibited interest by Article 18 is null, void, and wholly unenforceable. In essence, if a court were to conclude that a contract was in fact willfully entered into in violation of Article 18, the court could strike down that contract. So there certainly could be a serious consequence. There can also be misdemeanor sanctions for officers and employees who willfully and knowingly violate the interests in contract provisions. So as you can see here, there definitely are some things that can happen if there's a violation of Article 18. Also note that a conviction can serve as a basis for removal under Public Officer Law Section 36. So yes, there can be some serious consequences for a violation of Article 18. Now I'm going to kind of turn our attention to some other additional prohibitions. In addition to prohibiting interest in contracts under certain circumstances, Article 18 prohibits municipal officers and employees from engaging in several other types of conduct. Knowing and intentional violations of these provisions may be punishable by fine, suspension, or removal from office or employment in the manner provided by law. As you can see from the slide, Article 18 prohibits a municipal officer or employee from directly or indirectly soliciting a gift. The statute also prohibits a municipal officer or employee either directly or indirectly from accepting or receiving any gift having a value of $75 or more, under circumstances where it can be reasonably inferred that the gift is intended to or could reasonably be expected to influence him or her in performance of official duties or was intended as a reward for any official action. Article 18 also prohibits a municipal officer or employee from disclosing confidential information acquired in the course of his or her official duties. The statute also prohibits a municipal officer or employee from using confidential information to further his or her personal interests. Article 18 prohibits a municipal officer or employee from also receiving or entering into any agreement, express or implied, for compensation for services to be rendered in relation to any matter before any municipal agency of which he or she is an officer, member, or employee, or of any municipal agency over which he or she has jurisdiction or to which he or she has the power to appoint any member, officer, or employee. Note that this may include services rendered before a matter is officially submitted to an agency if, when the services are performed, the matter was likely to be submitted to the agency. Article 18 also prohibits a municipal officer or employee from receiving or entering into any agreement, expressed or implied, for compensation for services to be rendered in relation to any matter before any agency of his or her municipality when his or her compensation is to be dependent or contingent upon any action by the agency with respect to the matter. This provision, however, does not bar fees based upon the reasonable value of the services rendered. Finally, please note again that abstention and recusal does not cure a prohibited interest under this section. In addition to providing statewide rules relating to conflicts of interest on the part of municipal officers and employees, Article 18 also provides for supplementation of the statewide rules through the adoption of local codes of ethics. The statute requires that the governing body of each county, city, town, village, school district, and fire district to adopt a code of ethics setting forth standards of conduct reasonably expected of their officers and employees. Adoption by other types of municipalities is discretionary. Should you wish to review, our office has prepared a model code of ethics for municipalities available on OOC's website. We also have a model code for fire districts. Article 18 requires a code of ethics to address certain issues: disclosure of interest in legislation, holding investments in conflict with official duties, private employment in conflict with official duties, and future employment. A code may contain additional standards relating to conduct of officers and employees as may be deemed advisable. A code of ethics may also regulate or prescribe conduct not expressly prohibited by Article 18, but may not authorize conduct prohibited by Article 18. We have also concluded that a code of ethics may not prohibit conduct expressly permitted by Article 18. For example, a code of ethics can't overcome an exception set forth in Section 802, which renders an interest in a contract permissible. So an example that I can provide you is there's an exception, as you said, for a contract with a not-for-profit corporation. If you're associated with that not-for-profit, you can't put in your code of ethics that that exception is not allowed under your local code of ethics. Also note that the chief executive officer is required to cause a copy of the code to be distributed to each officer and employee. General Municipal Law Section 808 authorizes counties and other municipalities to establish boards of ethics. County Board of Ethics is established by the County Governing Board. If so established, Section 808 contains provisions relating to the composition of the board. The board renders advisory opinions pursuant to written inquiries to officers and employees of municipalities within the county with respect to Article 18 or local codes of ethics. However, the Attorney General's office has expressed the opinion that counties, towns, cities, and villages by local law may expand upon those powers. The Board of Ethics may also make recommendations with respect to drafting codes of ethics or making amendments to the Code of Ethics for municipalities within the county. Note that a Board of Ethics may also be established by a governing board of municipalities other than a county. If so established, the Board of Ethics has the same powers and duties and is governed by the same conditions as county boards. The board only acts with respect to officers and employees of that municipality, and if the municipality within the county has a board of ethics, the county board shall not act with respect to that municipality unless the local board defers the matter. Now I just want to turn your attention to disclosure of interest in certain land use matters. As I mentioned earlier in the presentation, Article 18 imposes the disclosure requirement in connection with every application, petition, or request for a variance, amendment, change of zoning, plat approval, exemption from a plat or official map, license or permit submitted pursuant to any ordinance, local law, rule or regulation constituting the zoning and planning regulations of a municipality. Such application, petition, or request must disclose the name, residence, and nature and extent of any interest in the application held by any state officer or any officer or employee of the municipality or any officer or employee of a municipality for which such municipality is a part to the extent known by the applicant. Please be aware the disclosure obligation is imposed on the person or entity making the application, not on the public officer or employee having the interest. Also, the circumstances under which a municipal officer or employee is deemed to have an interest in an applicant are broader than the circumstances under which a municipal officer or employee is deemed to have an interest in a contract. For example, a municipal officer or employee is deemed to have an interest in an applicant when the applicant is a parent, sibling, or grandchild. Now I just want to quickly talk about posting of certain provisions of Article 18. Article 18 requires the chief executive officer of every municipality to cause a copy of sections 800 through 809 to be posted in each public building in a conspicuous place. To help facilitate compliance with this requirement, our office has prepared a poster on these sections, which is available on the State Comptroller's website. If you have any trouble finding it, please reach out to us and we'll be happy to show you where it is. Finally, I wanted to briefly discuss that it is not necessary that a specific provision of Article 18 be violated before there can be an improper conflict of interest. Courts use a case-by-case approach in looking to the extent of the interest at issue and have stated that the public must be assured that officials are free to exercise their best judgment without any hint of self-interest or partiality, particularly if a matter under consideration is controversial. Actions of municipal bodies have been invalidated in the absence of disclosure and recusal if a violation of the spirit and intent of a statute inconsistent with public policy or suggests self-interest, partiality, or economic impropriety. For example, a court annulled the action of a village board which granted a zoning variance when a board member, who was a co-owner of the property for which the variance was sought, was the tie-breaking and decisive vote in granting the variance. This concludes the formal part of the presentation. I want to thank you for taking the time to listen to the presentation and hope that this was informative. At this time, I will now try to answer some questions.
We'll start from some hopefully simple ones. Does a police chief fall under municipal employee?
So the short answer is yes. My guess is a police chief, if they're an employee of the municipality, I would think that they would. So I think maybe where there's some confusion is sometimes you'll have volunteer firefighters, and the question is who within the volunteer firefighter service is eligible or qualifies as a municipal officer employee. And by virtue of just being a volunteer, that in and of itself does not make you a municipal officer employee for purposes of Article 18. However, if that individual has been elected by the membership to be the fire chief or the assistant fire chief, Article 18 does say that those individuals are subject to provisions of Article 18. So that's why that may be where the question is. Just to verify, if you have a situation where you're dealing with a fire company, which is organized as a not-for-profit, a couple of things. First of all, that contract with the municipality, there's an exception because they are a not-for-profit, so you don't have to necessarily worry about that. But depending on the individual and what their relationship is with the fire company, again, if they're the chief or the assistant chief, they would qualify, but just solely being a volunteer, that in of itself is not. Now that said, word of caution, we didn't really get into it today, but the general law does require that the fire company have its own separate code of ethics, and to make sure that if anyone who's listening is a volunteer, to make sure you're also complying with the fire company's code of ethics. I see here, can a treasurer own stock in a publicly traded bank in which the village has deposited accounts? So the answer may be yes, unless there's no other bank within the boundaries of the village. Board member's son becomes a salesperson for an existing vendor now, and the board member recuses himself on the purchase. Is it okay then if the remaining board approves such purchases? So there's a lot of different facts here that I don't necessarily know, but I'm going to just kind of do a very general answer here. As we discussed, there certainly would be a contract because the municipality is purchasing from this vendor. So the second question becomes, does this individual have an interest in that contract? As we pointed out, you're not deemed to have an interest in the contracts of your children unless there's dependent children. So I'm assuming that I'm going to guess this is an adult son and is not a dependent. Under those circumstances, the board member would not have a deemed interest in that contract. So unless the board member was receiving some sort of direct or indirect monetary benefit as a result of the son's relationship as a salesperson, my guess is that's not the case, then the board member would not have an interest in the contract. However, it would certainly be recommended that this person recuse themselves from any involvement and disclose that relationship, certainly to avoid any potential appearances of impropriety. So I think it's okay, but like everything, because there can be appearances, providing disclosure, abstaining, recusing, although not required under the statute, certainly will help alleviate any additional concerns here.
One person had a question of 501c3, so not-for-profit contract for a specific amount for services, but having the municipality pay for those costs, and then the 501c3 reimbursing the municipality for that, and if that's a conflict.
If the question is, can you enter into a contract where in 501c3, I'm assuming there's meaning that they are a not-for-profit, then the exception, there is the exception for not-for-profit, so you can enter into the contract if an individual has an interest in that contract, either because maybe typically it's because the individual is on the board of directors or an employee or an officer of that company. The local government can still contract with that entity, provided the individual, the person is required to disclose that interest.
I think they want to be cautious because just because a rate, like OGS, getting a state rate does not, it's extended to the municipality and may not actually be extended to the not-for-profit. So you want to be cautious about buying something on somebody else's behalf and then having them reimburse you because you're kind of giving to a not-for-profit that might not be eligible for that.
Can the fire commissioners appoint a spouse relative to be treasurer of the fire district? And I believe the short answer is there is no prohibition for family members to be members of the same municipality. So a common question, I'll kind of deviate a little bit. A common question we get is, can family members work for the same municipality? The answer is yes, but you have to be careful that a lot of local governments in their code of ethics and in our own model code, we have what's called a nepotism provision. So you shouldn't be like supervising family members, hiring those individuals, things of that nature. But under the assumption here, should you be appointing your spouse? Probably you should abstain and recuse from, if typically treasurers are elected, but you can in some cases appoint. So I would recommend not being involved in the process for having your spouse be either an officer or employee of the fire district, but there is no strict prohibition on that relationship. We do have an opinion that talks about that. Again, always recommending abstention and recusal will certainly help resolve any potential appearance issues. Can we do residential work if it is his company and gas has before it became supervisor. If there was a pre-existing contract before the individual became supervisor of the municipality, then that contract is okay. There's a pre-existing exception rule. However, if you're going to renew that contract, that would not be allowed. So I word of caution, depending on what type of relationship is transpiring here, it may be okay temporarily, but not permanently. I kept making reference to OSC's website. We do have opinions from 1988 to present on there, as well as that's our general phone number. You're welcome to contact that with any questions you may have. You're welcome to ask for myself, Mark Stevens. I just saw one more question here. I'll just do this one. Does a collective bargaining agreement, an employment contract, meet the definition of a contract? I mentioned that earlier on, that under the definition of contract, although a collective bargaining agreement would be considered a contract, in most cases, the contract is with a not-for-profit, and therefore an exception applies. So thank you very much. I very much appreciate everyone taking the time to listen to this presentation. I hope it was informative. And as always, please know that we are a resource available should you have any future questions. Thank you.